Estate planning mistake number 5. After I'm gone, my beneficiaries can receive my assets out of the living trust and handle it fine on their own. Well, you may think that beneficiaries are capable of managing. Of course, in some cases, they're not. They may be too young. They may be ill or disabled. They may have special needs. They may be getting government benefits. They may be a spendthrift. You know what I mean. They spend more than they take in. Those types of beneficiaries clearly should have their inheritance held in the trust and managed for them. But now I'm addressing a bigger mistake. That is where you feel my beneficiaries are old enough and wise enough to handle their inheritance on their own. The problem is most people don't realize what happens when a living trust is ultimately distributed to the beneficiaries. And when I say most individuals, that includes a lot of attorneys as well. At our law firm of Kavesh, Minor & Otis, we've handled over 2,000 trusts after people have passed away. And here's the dirty little secret we've discovered. What happens after people receive their inheritance from their living trust is perhaps more important than everything leading up to that point. Even if they've avoided probate and estate tax, when people receive assets directly out of the trust into their name, a whole lot of bad things can happen. They can get divorced and lose their inheritance. They can have a lawsuit. They can run up creditors or debts or have a bankruptcy. They could have benefits that they're receiving from the government that are now taken away or have to be repaid. And even if you have that perfect beneficiary who receives your assets out of the trust, does a good job reinvesting them and compounding them on top of his or her own assets, when that beneficiary passes away, bam, now there's potential for another estate tax when it passes down to the next generation. We've found at Kavesh, Minor & Otis there's a much better way for people to receive their inheritance through what we call a personal asset trust. This is a wrapper, a protective wrapper around their inheritance that they receive when it comes from the living trust to them. A trust vehicle that they control so the beneficiary can decide how the assets are used, how they're invested, who even gets them after he or she passes away. Pretty much the same rights they would have had if it came out directly in their name. But coming out in this personal asset trust wrapper, now that trust gives them legal protection, legal walls that give them much enhanced protection against the spouse in a divorce, the creditor, the lawsuit, the loss of government benefits, and the second estate tax. This personal asset trust vehicle is so unique that we license this to other attorneys from all across the nation and train them how to use this important protective device. But beyond that, we also help make sure that your beneficiary will drive this protective vehicle properly when the time comes. Because along with your trust, the beneficiaries also get a personal asset trust beneficiary manual in easy-to-read checklist form to make sure that that Brinks truck that holds their inheritance will continue to protect it properly as they drive it into the future. And for those beneficiaries who don't read, we also have a quick start DVD right here of about 35 minutes to give them the important driving lessons that they'll need to drive that personal asset trust properly when the time comes. These are the types of things that make a difference between a well-drafted trust and a poorly drafted trust. Experience and expertise do count when it comes to choosing your estate planner.